My daughter left me alone in a hospital bed in a city I didn't know, without my wallet, without my phone, and with a discharge form that had the wrong emergency contact. She did it on purpose. I know that now. What she didn't know was that I'd be home before she was, standing in the living room she'd already started rearranging, holding the document she thought I'd never find. When she walked through the front door, I was sitting at the kitchen table with a cup of coffee. I said, "How was the drive back?" She didn't say a word for 11 seconds. I counted. 3 weeks before any of this, my daughter called to say she'd found the perfect place for us to go together. Father-daughter trip. She used those exact words. She said I'd been working too hard since her mother passed, that I needed to get out of the house, see something new. She said she'd handle everything, flights, hotel, the whole itinerary. "Just pack a bag, Dad." I've got it. I should tell you something about my daughter. She was always the organized one. Her mother used to say she came out of the womb with a color-coded calendar. She runs the household like a project. Lists for everything. Never a spontaneous bone in her body. So when she started calling more often in February, checking in, dropping by unannounced, asking questions about the house, I thought it was grief. She lost her mother 8 months prior. I thought she was circling back to me the way children sometimes do after a parent is gone, suddenly aware that the other one won't be around forever. I was wrong about what she was circling back for. The trip was to Savannah, Georgia. She lives in Charlotte. I live outside Richmond, Virginia. We'd fly down together, spend 4 days, come home. My son-in-law didn't come. He had work, she said. Now I wonder if he had different work to do. The first 2 days were fine. We walked the squares, ate at the restaurant she'd researched, saw the cathedral. She was attentive, pleasant. Asked about my retirement accounts once. Casually, the way you'd ask about the weather, and I answered without thinking. Said I was comfortable. Said the house was paid off. Said I'd reviewed my estate documents last year. Her expression didn't change. She just nodded and looked out at the water. On the 3rd morning, I woke up with chest tightness. Not severe. I've had it before. I'm 64. I take a blood pressure medication. I know my body. But my daughter heard me breathing differently at breakfast and said we needed to get it checked. I said I was fine. She said she wasn't willing to take that risk with her father's health. She was so insistent, so loving about it, that I let her take me to the urgent care clinic on Drayton Street. The clinic was quiet. A nurse checked my blood pressure, said it was elevated but not alarming. They wanted to do an EKG. Daughter said she'd run to the car to get my insurance card since I'd left my wallet in the hotel safe. Responsible, I thought. That's my daughter. She left at 10:22. The EKG came back normal. I waited until 11:15 before I asked the nurse to try my daughter's number from the clinic's phone. No answer. At noon, a different nurse asked if I had someone to call. I said my daughter was in the parking lot. She gave me a look I didn't understand yet. At 1:30, I walked out to the parking lot myself. Her rental car was gone. I stood in the Savannah heat with a discharge form in one hand and no phone, no wallet, no ID, and no way to reach anyone I knew. The first thing I felt was confusion. Then something colder moved in underneath it. This wasn't a misunderstanding. The clinic's receptionist, a young woman named something I didn't catch, let me use the desk phone. I tried my daughter's number from memory. Voicemail. I tried my son-in-law. Same. I called my neighbor back in Richmond, the man who'd lived next door for 9 years, retired postal worker, reliable the way certain men are reliably, quietly good. He picked up on the second ring. I told him where I was and what had happened. He said, "Stay right there. I'm calling you back in 10 minutes with a plan." He called back in 8. He'd looked up the nearest branch of my bank and the address of the U.S. situation for ID replacement. He walked me through what to do in order. I wrote it on the back of my discharge form with a pen borrowed from the receptionist. First, bank. Second, ID. Third, figure out what she took. The bank branch was 6 blocks away. I walked it in the heat. The branch manager was a man with wire-rimmed glasses and the careful manner of someone who handles difficult conversations regularly. I explained the situation without embellishment. He asked security questions, verified my identity through the system, and issued me emergency cash against my account, $300. He also confirmed, and this was when I first felt the ground shift under me, that 2 days ago, someone had logged into my online banking portal and changed the notification email to an address he couldn't fully show me, but that began with my daughter's initials. She'd been in my account. I kept my voice level. I asked him to freeze any transfers pending his fraud team's review. He said he'd flag it immediately. He handed me the cash in an envelope and shook my hand with both of his. Outside on the sidewalk, I stood in the shade of an awning and did what I always did when a business situation turned serious. I stopped reacting and started thinking. She had my wallet, my driver's license, my credit cards, my insurance card. She'd known about the clinic in advance, the location, the process. She'd counted on the EKG taking time. She'd had that rental car pointing toward the interstate before I'd finished reading the discharge instructions. The question was, what was she trying to do with the time? The answer arrived with a kind of cold clarity I hadn't felt since the year I almost lost my business to a supplier fraud in 2009. She was going home. And she wasn't going home empty-handed. I got a replacement ID at the Georgia DMV office that afternoon, with a temporary travel permit. My neighbor had already contacted a colleague of his, who knew a notary, who knew a paralegal, who told him what documents to look for if a property transfer had been filed recently in Virginia. He called me at the payphone outside the DMV. Yes, there was still a payphone, and told me to get back to Richmond as fast as I could. I bought a bus ticket with $47 of the emergency cash. 9 hours. I sat in the back row and didn't sleep. I got home at 6:40 in the morning. My neighbor met me in the driveway. His face told me before his words did. She was here, he said, yesterday afternoon. She and her husband. They were inside for about 2 hours. He'd watched from his window. Hadn't interfered because he didn't have cause. But he'd taken photographs on his phone. Timestamps. Everything. The house looked the same from outside. Pale yellow siding, black shutters, the oak tree her mother planted in 1991. I'd bought this house when I was 31 years old, paid it off at 57, raised my daughter in the bedroom, with the window that faced the backyard. I unlocked the front door with the key I keep on a chain around my neck. I'm the kind of man who keeps the key on a chain, and stepped inside. The silver candlesticks from the dining room sideboard were gone. My wife's jewelry box was on the dresser but empty, the velvet interior bare. The filing cabinet in my study had been gone through. I could tell because I keep a particular system, and the folders were slightly out of order, the way they get when someone who doesn't know the system tries to put things back. On my desk, centered the way you'd center something you wanted found. I opened it standing up. Quitclaim deed. My name is grantor. My daughter's name is grantee. Property description matching my address exactly. Date, February 28th, 6 weeks ago. My signature at the bottom, notarized, officially recorded with a county. I read it twice. Then I sat down in my desk chair and let the silence hold for a moment. February 28th. That was the day she'd come to visit unannounced, brought lunch from the deli, sat at this very desk with me to update some paperwork. She'd said it was a healthcare proxy update, in case something happened, Dad. She had her laptop open. The document was already on screen, small text, and she scrolled through it quickly, explaining in her organized voice what each section meant. I signed with the electronic stylus. She said she'd file it and send me a copy. I never received a copy. The document on my desk was the copy. I sat there for 90 seconds allowing myself to feel what I felt. Then I picked up the phone and called my neighbor. Can you come over? I need a witness for some photographs. He was at my door in 4 minutes. We documented everything. Every empty space where something used to sit. Every folder in the filing cabinet. The quitclaim deed from every angle. His photographs of her car in my driveway from the day before. I made him write a brief account by hand on a legal pad, describing what he'd observed and when. He signed and dated it without being asked. When we were done, he made coffee. I sat at the kitchen table and called my bank again to confirm the fraud flag was active. It was. No transfers had gone through. She'd changed the notification email but hadn't moved any money yet. Another day and she might have. What are you going to do? My neighbor asked. I'm going to call a lawyer, I said. And then I'm going to change my locks. The locksmith came at noon. His name was something short and practical, and he worked without talking, which I appreciated. New deadbolts on the front door, back door, and the door to the garage. $290. He handed me 4 keys. I kept 2, hid one in the false bottom of the planter my wife made in a ceramics class, gave the last one to my neighbor. At 2 o'clock I sat in the office of an attorney named Whitfield, recommended by my business attorney as someone who handled real estate fraud specifically. His office was on the 3rd floor of a building near the courthouse, books on every wall, the kind of organized clutter that signals someone who actually uses what they own. He examined the quit-claim deed for 4 minutes without speaking. "This is recorded," he said finally. "As of February 28th, your daughter legally owns this house." "I know," I said. I didn't know what I was signing. He looked at me over his glasses. "Walk me through exactly what happened." I did. The lunch, the laptop, the small text, the electronic signature, the explanation that it was a healthcare proxy. He made notes, asked 3 clarifying questions. Did I receive any copy of the document at the time of signing? No. Did the notary meet me separately? He hadn't. I'd signed electronically on her laptop. I had no memory of a notary present at all. Had I ever received a recorded confirmation from the county? Never. "That's our opening," he said. He turned to his computer and typed quickly. "If she told you it was a healthcare proxy and it was actually a property transfer, that's fraud in the inducement. We filed to void the deed on grounds of misrepresentation." He told me the costs. Retainer of $4,000. Full litigation could reach $30,000 or more if my daughter fought hard. He said it directly, without softening it. Said she'd probably fight because she'd already recorded the deed, already seen the house as hers. Said she might counterclaim that the gift was voluntary and my current position was remorse. "I have resources," I said, "and I'm not remorseful. I'm defrauded." He nodded once. "Good. That's the right framing. Let's begin." The police report came next. East District, mid-afternoon. Fluorescent lights, plastic chairs, a young officer who typed slowly and asked careful questions. The stolen items, my wife's jewelry, the silver candlesticks, other things I itemized from memory, had serial numbers where applicable. The wallet with its contents, the phone. I explained that the theft occurred in Savannah, and also here, in my own home. The officer's expression shifted slightly when I told him my daughter was the person responsible. "Family matters often have to go through civil court," he said carefully. "The theft of physical property doesn't," I said. "The wallet, crime regardless of relationship." He took the report. Case number written on a card he handed me. His face said he wasn't optimistic, but he did his job. Back home that evening, I sat in the quiet living room and allowed myself 10 minutes of doubt. The legal costs, the uncertainty, the fact that my daughter had clearly planned this carefully, which meant she'd hired someone who knew what they were doing. I thought about how long she must have been sitting with this plan, coming over for Sunday dinners, calling to check in, asking about the estate documents, how long she'd been calculating the square footage of her inheritance while I was still breathing. The 10 minutes ended. I went to my desk and started a log. She called the next morning from I didn't recognize. I answered, "Dad." Her voice was the same as it always was, measured, organized. "I think we need to talk about what's been happening." "We do," I said. "You left the clinic. You never called me to this clinic." "You never—" I was worried. She was going to try the concerned daughter version first. I'd expected that. "The discharge nurse called your number," I said. "No answer. I've been home since yesterday morning. My locks have been changed." Silence. Then, the locks. I found the quitclaim deed. Longer silence. "Dad, I can explain. You'll have the opportunity to explain to a judge," I said. "I've retained an attorney. You'll be served with the motion to void the deed in the next few days." Her voice shifted. The measured tone hardened. "That deed is legally recorded. You signed it. Your signature is notarized." "I signed what you told me was a healthcare proxy," I said. "That's misrepresentation. That's fraud. My attorney is confident about this. We're not giving up the house. I'm not giving up my house," I said. "Good luck with the legality of that position." I ended the call. My hand was steady. The anger was there, but it was cold, organized, almost useful. The same thing happened in 2009 when I realized the supplier was falsifying invoices. The outrage clarified into action. I recorded the call. Virginia allows one-party consent. I sent the audio file to my attorney that afternoon. Whitfield called 3 days later. My daughter had retained a lawyer, someone who specialized in elder financial planning cases, which told me something about the strategy she intended to use. She was going to argue cognitive decline. She was going to say I'd made the gift knowingly and was now confused about having done so. "She's going to say I'm not in my right mind," I said. "Probably," Whitfield said. "Which is why I'd like to get you evaluated now, preemptively by a neuropsychologist we work with regularly. If we have a clean evaluation on record before she files that motion, it takes the argument off the table." I sat for the evaluation. 4 days later, 3 hours. Word lists, pattern recognition, memory recall, decision-making exercises, a detailed interview about my professional history. I told the examiner about building my transportation logistics company from a truck and a phone in 1988, running it for 27 years, selling it in 2015 for more than I ever thought it would be worth. He took careful notes. The report came back 7 days later. Intact memory function, age-appropriate processing speed, no signs of cognitive impairment, fully capable of understanding legal documents and making informed decisions. Whitfield sent a copy to my daughter's attorney with a note. Meanwhile, I'd hired an investigator. My neighbor knew someone through his son who was an accountant and had used the same investigator for a business dispute. She was a compact, direct woman who asked good questions and charged a fair rate. She called me 2 weeks in with what she'd found. My son-in-law had substantial debt, not the visible kind, not overdue utilities or a car payment behind, the hidden kind. Business loans that had gone sideways, personal credit lines drawn to their limits, a lawsuit from a former partner that had settled quietly but expensively. He'd been financially underwater for 18 months. The house had been appraised, not by anyone I'd hired, in January. The value came back at $740,000. He needed the asset, she said. Your daughter probably told herself it was just early inheritance. But the timing matches his financial crisis exactly. She sent me documentation. Loan records, the appraisal request, email communications she'd obtained through legal channels. I read through them at my kitchen table on a Tuesday night with the lamp on, and the rest of the house dark and quiet. My daughter had gone to real estate attorneys in January, before the trip, before the document signing. She'd asked about the cleanest method to transfer a property from a parent to an adult child. She'd researched whether a gift deed could be challenged and under what circumstances. She'd looked up what constituted valid notarization in Virginia. She'd planned this the way she planned everything, with a list. I sat in the dark for a while after reading that. Not crying, I'm not built that way, or maybe I used up those reserves in the year after her mother died. Just sitting, thinking about the little girl who used to make color-coded charts for her chores, about the woman who held my hand at her mother's funeral, about the distance between those two images and the document on my desk. I allowed myself 1 hour of that. Then I went to bed. The preliminary hearing was 6 weeks after I filed. Courtroom in the county courthouse, neutral lighting, the smell of old paper and floor cleaner. I sat at the plaintiff's table with Whitfield. My daughter sat across the room with her attorney, a tall man named something I won't write here, in a good suit that wasn't quite right for the room. My son-in-law sat beside her, stiff-shouldered. First time I'd seen them since she'd walked out of the clinic parking lot. She didn't look at me directly. He looked at the table. Her attorney opened by characterizing the deed as a considered estate planning decision, mutually understood, properly executed. He described my position as a change of heart dressed as a fraud claim, driven by family conflict. He was smooth, well-prepared, and clearly expensive. Whitfield presented the notarization issue first. Under Virginia Code, a notary is required to personally witness the signing of a document. I had signed electronically on my daughter's laptop. No notary had been physically present. We'd tracked down the notary whose seal appeared on the deed, a freelance notary who worked out of a home office in Chesterfield County. Whitfield had spoken with him. The man confirmed that my daughter had brought the document to him after the signing, described me as her off-father who had authorized it remotely due to health limitations, and paid him in cash to apply his seal. He'd done it. He regretted it. He'd written a signed statement. The judge, a woman in her 50s with a reputation for patience and precision, leaned forward slightly when Whitfield read from the notary's statement. She asked one clarifying question. Had the notary personally observed the grantor signing the document? He had not. Her attorney objected to the statement's admissibility. The judge noted the objection and moved on. Her expression didn't change, but something in the room did. Whitfield then presented the investigator's findings. The financial situation, the January appraisal, the research into deed transfer methods. This is not an estate planning conversation gone wrong, Whitfield said. The evidence establishes that the grantor was deliberately misled about the nature of the document he signed, as part of a pre-planned scheme motivated by the defendant's financial crisis. The Savannah incident was not spontaneous. It was designed to provide time for the defendant to establish physical possession before the grantor could return and contest the transfer. My daughter's attorney called her to the stand for direct examination. She was composed, prepared. She said I had asked her to help me update my estate documents. She said she'd explained the deed clearly. She said I had read it before signing. Whitfield's cross-examination was short and precise. You told the notary your father had health limitations that prevented him from coming to the notary's office personally. Is that correct? She paused. I may have mentioned he'd been having some health concerns. At the time of the document signing on February 28th, was your father experiencing any health limitation that prevented him from traveling? Longer pause. He'd mentioned some fatigue. Yes or no? Was your father physically incapable of traveling to a notary's office on February 28th? Not. No. You paid the notary in cash. That's not. I paid for convenience. He offered cash pricing. The standard fee for a notarization in Virginia is between $10 and $25. You paid $300 in cash. Is that accurate? She looked at her attorney. He gave her nothing. I wanted to ensure quality service, she said. I watched my daughter's face during that exchange. Saw the tell I'd known since she was 7 years old, a slight compression at the corners of her mouth. When she was saying something she knew wasn't true. She did it twice on the stand. The judge ordered a 60-day discovery period and a follow-up hearing. She did not grant my daughter's motion for interim possession of the property, which had been filed the previous week, on grounds that she was the legal owner being denied access to her home. The denial was brief and precise. Discovery produced more than expected. My assistant found a storage unit rented in my son-in-law's name. A police request facilitated by Whitfield's filing resulted in a search. My wife's jewelry was there. The silver candlesticks. A painting from the hallway I hadn't even noticed was gone. Everything cataloged. Everything photographed. Whitfield called me when he got the news. His voice was as measured as always, but I could hear something under it. This shifts the case significantly, he said. Physical evidence of theft held in a rented storage unit is harder to explain than missing items from a home. My daughter's attorney called that same afternoon with a settlement offer. My son-in-law would relinquish any claim to the property. My daughter would sign a corrective deed. In exchange, I would drop the theft complaints and agree to a payment to cover their relocation costs. $50,000. I was quiet for a moment. No, I said. Whitfield advised me to consider it. Took 10 seconds. Still no. I'm not paying my daughter $50,000 to return what she stole from me, I said. If she wants to make this right, she makes it right. No payment. He called back 2 days later, offer revised. No payment, just the deed transfer and dropped charges. I discussed it with Whitfield seriously this time. Weighed the costs of continued litigation against the certainty of outcome. Decided I wanted a court ruling on record, not a private settlement. I wanted the documented finding that what happened to me was fraud, not a family disagreement, not a change of heart. Fraud. We went back to court. The follow-up hearing was 38 days later. New evidence in the record, the notary's sworn statement, the investigator's financial documentation, the storage unit contents, the timestamps on the January appraisal request, the cash payment to the notary. My daughter's attorney made a strong argument about the validity of the recorded deed. He was good, I won't pretend otherwise. But the notarization issue was structural, and it was difficult to argue around. A deed that lacks proper notarization has a significant validity problem in Virginia. A deed where the notary was paid 12 times the standard rate to skip the required in-person verification has an even larger one. The judge took 40 minutes in recess. When she returned, she delivered her ruling without preamble. The quitclaim deed was declared void on grounds of fraudulent inducement and defective notarization. Title remained with me. My daughter and son-in-law were ordered to return all personal property within 48 hours. The court referred criminal matters, the theft, the notary solicitation, to the prosecutor's office. I drove home in the afternoon light, parked in my driveway. Sat in the car for a moment, looking at the house. My neighbor was on his porch. He raised a hand when he saw me. I raised one back. Inside, I put the kettle on. Made tea. Stood at the kitchen window looking at the backyard, at the oak tree, at the garden bed that needed work before winter. The house was mine. Not just in feeling, it had always been mine in feeling. Now it was mine in the record. The stolen items came back in a cardboard box left on my porch without a knock. The jewelry was all there, the candlesticks, the painting. I unwrapped each piece and put it back where it belonged. My wife's rings went back in the jewelry box. I closed the lid and left it on the dresser. The prosecutor's office offered a plea agreement 3 weeks later. My son-in-law would plead guilty to 1 count of theft, receive 2 years probation, and make restitution for the legal costs I could document. My daughter's charge would be reduced to a misdemeanor, with a fine and community service. No incarceration, given her lack of prior record. I asked the assistant prosecutor if he thought it was proportionate. He said it was the standard offer in cases like this. I said yes, my attorney's final bill was $22,000. I paid it. He'd told me up front what it would cost, and he'd been within range. I respect that in a professional. I rewrote my will the following month. New estate attorney, different firm, clear language. The house, upon my death, would pass to the residential trust I'd established, designated for transitional housing for aging veterans in the county. My daughter was named explicitly, by legal requirement, and explicitly excluded. It's not punishment, it's protection. Those are different things. My neighbor came over in September. We sat on the porch with iced tea and watched the street the way you do when you're both old enough to find that satisfying. He asked if I'd heard from my daughter. Once. A letter, not a call. She said she was sorry, said things had gotten out of control, said she'd never meant for it to go as far as it did. I thought about what to write back for a long time, I wrote. I believe you didn't expect to get caught. I don't believe that's the same thing as not meaning it. I mailed it. I haven't heard back. My neighbor asked if I thought she'd try to make contact again someday. I said I didn't know. I said I'd cross that road when I came to it. We sat there until the streetlights came on. He went home. I went inside, locked the door with my key, the new one, the one she doesn't have, and stood in the living room for a moment in the quiet. The candlesticks were back on the sideboard. The painting was back on the wall. The oak tree was visible through the window, dark against the evening sky. I'd defended this house, with a bus ticket, emergency cash, a neighbor who picked up on the second ring, and a lawyer who charged a fair rate. I'd done it without losing my temper once, without saying anything I regretted, without letting what she'd done make me into someone I didn't recognize. That matters to me. Maybe more than the house itself. Justice isn't always clean. It doesn't undo what was done or give back the months spent watching your own child lie under oath. It doesn't fix the thing that was broken between her and me, which I suspect was broken longer than I knew, and only became visible when the money got tight and the pressure got real. But it's necessary, and I had it. That's enough.